Good morning again. If you need coffee to stay awake for this presentation, I recommend you go to the back of the room and get a nice hot cup of Starbucks just to stay awake. But I'll try to be entertaining. Hainipi Chinook Maninga Hingai Day. Chinook Maninga is my Indian name from my Ho-Chunk side. As you saw, my dad is here. My dad's Oneida, my mom is Ho-Chunk. I'm enrolled at Ho-Chunk. I've worked many, many years for Ho-Chunk and continue to do work for Ho-Chunk. I also have done some work, thankfully, for Oneida, and I'm one of the few Indian attorneys out there that her own tribe actually hires her. So very, very, very happy about that and thankful. So I'm here to talk about a really big subject, environmental justice 101. This is, literally the can of worms. It is the can of worms for Indian country. It's the can of worms for all of your jobs. As I was listening to some of your names, where you're from, and some of your job capacities and why you're here, I could think of a million different ways environmental justice touches you. And if it doesn't, I'm sure it is definitely right up your alley. And I applaud Melinda and Kelly and Danielle for sitting down and taking 2 or 3 steps back from their work and trying to offer this forum for you to kind of wrap your heads around, what are we really trying to do here? Is it really just an agreement? Is it really just a DOT project? Looking at the bigger picture and the larger scheme. A little bit about me, I did grow up down the road, like my dad said, 4 miles away from here. And I remember I was around here before there was the casino. My grandmother's pretty active in the community, and I helped her bake cookies to make payroll when they first opened the casino and didn't have the money. So it's always nice to come and do something here at the Radisson and see, of course, renovations and hear renovations and see that this place just keeps getting bigger and better every time I come up here. So I applaud Chairman Delgado and other folks from Oneida that are working every day to make that happen here. And it's nice to come home. I'm again from here. I went to undergraduate down at Madison, so I'm a Badger, law school at University of Denver. I studied international law and indigenous peoples law in Europe on a couple occasions in Vienna, Austria, and Geneva, Switzerland. I've kind of been all over the country working for numerous tribes, been in private practice for a little over 7 years now. Majority of my time in practice, I worked at a law firm called White Hirschbeck Dudig. You may know them from Wisconsin. They're based out of Milwaukee. Medium for Wisconsin, a large size law firm, 150 attorneys or so, and that's where I did a lot of private practice work. I thankfully fell in love with the man in the back corner, Corey Skenandore, and I moved down to Arizona. Out there, I'm working at a law firm called the Schenker Law Firm. And folks may or may not know of the Schenker Law Firm. I've known of Howard Schenker before I even took the LSAT and went to law school. Howard Schenker he is a critical and very effective tribal attorney out in Indian country. He's not native, he's a Jewish guy from Jersey who ended up going to big law firms and getting an Indian law case and doing very well. Got into environmental law, environmental justice, and for over 25 years now, this man takes on some of the biggest, ugliest cases against the federal government usually, and of course the EPA and permitting processes in this country. So I've been watching his work long before I even went to law school, knowing that he and several other federal litigators were my mentors and people who I aspired to be, and one day would hopefully work on cases like that. So luckily enough, when I decided to move to Arizona, I called up Howard on the phone and just said, "Hi Howard, hi Mr. Schenker, my name's Samantha, I'm moving to Arizona and I want to work for you." And he said, "Oh, okay, well, let me, we don't really have an associate, it's a husband-wife team. His wife is also Native. She was born and adopted out of her Indian community and grew up in a non-Indian community. And as she got older, she experienced foster care, Indian child welfare, firsthand, and she vowed to become an attorney and place and keep kids in with their Indian communities. And to this day, 20-some years later, Tamara Schenker, who's Howard's wife, she now advocates for Indian children to stay in their Indian communities, and that's what she does on a full-time basis. Very well known and renowned and loved down in Arizona. So I have this wonderful, these 2 attorneys that are my mentors now. And if folks, we'll talk a little bit about this case in a minute. Probably you may have heard the San Francisco Peaks case down by Flagstaff, Arizona, where the tribes were fighting to save a sacred site. That was Howard Schenker's case. So luckily when I came to the firm, we were in the midst of Ninth Circuit litigation, and I was able to jump in and help him with the case. So without further ado, we'll move forward with this presentation. The writer of the Federal Indian Law book, which is the foundation of my practice and also governs how you do your jobs and why you do your jobs the way that you do, he actually died in 1953, and after working for decades studying and being the biggest scholar in Indian law, one of the last things he said, which is quoted right in the front of the Federal Indian Law Handbook, is this quote, and we're considered the miner's canary. It says, "The Indian plays much the same role in our American society that the Jews played in Germany. Like the miner's canary, the Indian marks the shift from fresh air to poison gas in our political atmosphere, and our treatment of Indians, even more than our treatment of other minorities, reflects the rise and fall in our democratic faith." So here's a man of scholar looking at our treaties, our sovereignty, our agreements, our case law, our Supreme Court cases, and tells us that we are analogous to miners' canaries. There's this man walking down, this miner walking down with the canary in a cage, and if anybody knows, the analogy here is they would typically, when they're expanding or doing more work in any mining location, they would bring a canary down to test and see how poisoned the gas were. And when the canary died, then they knew that they had to, deal with that, maybe not work there, ventilate it, or they wouldn't send their workers in to do work there. So the analogy is that obviously we're testing the boundaries. Indians are America's canaries. So they use us and they test our boundaries. And eventually, obviously, there's death, there's terrible repercussions when we run into these areas where the quote unquote poison gas is. So this is really the rubric of Indian law that we have to deal with. It's very depressing, is it not? Back to environmental justice. We just call it EJ for short. EJ is a very, very broad and dynamic concept of all things. It's environmental justice, and essentially it's a civil rights issue at the heart. And what that means is when we are making decisions as a society, and of course there's all these bubbles of society, tribal societies, communities, local, regional, national, when we make these decisions that affect our environment, they're supposed to be made fairly, and they're supposed to be made in a meaningful manner. So environmental justice is from any one of those communities, any one of those parties, plaintiffs, individuals, groups of people, when they have an issue with the way a decision is made, when it's not made fairly, and more than likely discriminates against a minority group or a low status socioeconomic group, that gives those people the right to find justice in that decision. So environmental justice is essentially finding justice with decisions that adversely affect our environment, particularly those that happen upon the folks that are oppressed, where these projects end up being cited, placed, fast-tracked. We see the DNR getting asked to change their rules to accommodate certain industries. Here in Wisconsin, it's the same environmental justice issues that falls under this umbrella. I'm not going to read everything to you on the PowerPoints. I did put this presentation together to be more wordy than not, so you could take it home with you, look at it. If you have some time to think about things, you can read a little bit more in the words here. But generally, it's negative disparate impacts on low-income and minority communities that take a variety of forms. And these are the distinct forms that you see in case laws. This is the things the attorneys will tell you should file for, or you have a claim about. Inequitable distribution of unwanted or unhealthy facilities, lax enforcement of environmental laws, or inadequate inclusion or consideration in the development and issuance of permits, policies, and regulations. And that's general. Does that make sense what environmental justice is generally? It's a lot of things. It could be the road project down the road here. It could be invasive species, as Melinda was talking about earlier, how that's handled. All those sorts of things. Now, what's interesting to know is, well, who in the United States generally is the granddaddy of environmental justice? And that's kind of a no-brainer. It's the Environmental Protection Agency. So what do they do? What is their policy on this? And I'm going to read you some really fancy words, but I want you to pay attention to what the policy vision is behind all of this environmental justice. And what this says is, and this is right off the EPA website, environmental justice is the fair treatment and meaningful involvement of all peoples, regardless of race, color, national origin, or income, with respect to development, implementation, and enforcement of environmental laws, regulations, and policies. The EPA has this goal for all communities and persons across this nation. It will be achieved when everyone enjoys the same degree of protection from environmental and health hazards and equal access to decision-making processes, and to have a healthy environment in which they live, learn, and work. So that is a big goal of the EPA, and we're going to see how well they play against this goal of theirs. So environmental justice in Indian country, and this is great because I have my own ideas after reading hundreds, probably thousands of law cases, and of course watching. I'm a watchdog. I'm constantly, I spend literally about an hour and a half every morning going on the internet, finding out which cases were filed. Has the court made a decision? Did they slip an opinion out in the middle of the night when I was sleeping? I want to know first thing in the morning. So I have this, sick OCD case law issue that a lot of attorneys do because we're just dying to know what's going to happen next. And so in my mind, after a series of all of that reading, I have my own ideas of what EJ is. EJ, what it's supposed to be, what we strive for it to be, but what it really is in 2013. And I believe I've been hired here today to tell you what it really is and to give you some ideas going forward with that and know where your place is in 2013 in terms of environmental justice in Indian country. Now, in a nutshell, environmental justice for what it means to you working with tribes will depend primarily on two components, and it's tribal governance, not necessarily even state or federal governance. It's mainly how the tribal government decides to work with the rules that be. We can work on policy changes for down the road, but they're right today in 2013, there's a set of rules we have to play by, and so it's how the tribal government will respond, if at all, how they respond to that set of rules today, and the activism. And activism can come within the tribe, it can come outside of the tribe, it can come from non-tribal members, and it's really interesting when you see tribes filing these big cases on environmental justice. And 9 times out of 10, it's really not coming from the tribe, it's coming from the Sierra Club or some other watchdog group or Save Our Waters, and they're collecting and finding all this money, and they're partnering with tribes, and they're the watchdogs and helping, move a lot of these fronts forward. So in the mix of things, it really is a very dynamic mix of politics, and environmental justice is really tough because, do you bite the hand that feeds you? We were talking about the BIA yesterday. Do you want to really go up there and shake the cage on them and say this is really how things need to be? But then you have how many 638 contracts from them? You got to be very careful and choose your battles wisely. So there's politics at play. There's cultural issues at play. We're a living, breathing indigenous groups of people, always moving, changing, and morphing into modern day society. What is the culture of the group? Does this goal of environmental justice meet our goals as a people? And the social climate, and this is actually my mom up here dancing at, I believe, Oneida Powwow this past summer. So that's my mom, Elena Greendeer. And part of the social aspects is, for instance, powwows, this cultural collection of our cultural identity, our socialism, our families, the backbone of who we are and how we are really living in today. What part of that social aspect requires us to seek environmental justice? Do we want the Norbert Hill Center and the lands around it preserved so we can continue to have powwows? There's a lot, again, a loaded question of many things for us to preserve our social nature as indigenous peoples. And the last part is probably the most difficult, and we have a mining site here, and I have the road of ethics. Ethics is a very, very big topic that I think people don't talk enough about. Like, what is environmentally ethical to do? What is the ethics of the tribal approach and the vision for the environment? Is it ethical? If we stay out of this litigation, is it ethical? Is it ethical to join a litigation? How can we get other people to fight our battles? All these ethics are employed into those decisions. And then not only that, the developers, the state folks that are issuing permits, the federal folks that are issuing permits and promulgating these policies, is there ethics incorporated into those decisions? That review process. And so it's a very dynamic decision-making process. And for components in Indian country, they take this on as a very holistic approach. For non-tribal communities, of which I do certainly my share of law practice with non-tribal clients, they don't really necessarily go through this matrix of thought. It's really just bottom line. And to me, I always call it a no-brainer client. Like, how can we raise your bottom line and keep you out of the red, put you more in the black? And that's really how they base their decisions on. It's a business decision versus this type of very dynamic decision. So that's what a nuance I just wanted to point out to you early on in understanding how this works in Indian country. This right here, does anybody recognize this view right here? Has anybody been there? Is Chairman Delgado still here? I'm sure he's been there. On your left is called the Hall of Nations, and that's at the Bureau of Indian Affairs. So that's the hall you walk through to go talk to the Assistant Secretary of the Interior or his attorneys or any of his legal aides or policy advisors. I've been fortunate enough to have been walking through those the past 7 years and working on a number of topics, but this is very important to understand for Indian country. Overall, and quote me on this 20 years down the road, our lands and our communities are some of the last frontiers that have not been touched in certain ways by different projects. We are the last frontier because of our sovereignty, our regulations, our boundaries, all of our dynamics of our own self-governance have kept our lands pretty pristine, although environmental people probably beg to differ in some aspects. But generally, it's the last frontier for energy development, nuclear. We are getting asked, FERC has to deal with a ton of these things. So in the Hall of Nations, the BIA has a really tough job because they have to balance all of those national needs with their trust responsibility to tribes to preserve our tribal lands, the land we're actually on now. And so when you're going in there to talk with them, and you walk down through these flags and you talk with them, it's so hard to see an Indian person sitting across the table because they're struggling with the policy decisions of their employer. At the same time, they're trying to help you out whatever way you can. So it's a really difficult task to tackle environmental justice, right here where it really does happen at the Bureau of Indian Affairs. On this side, this is Bear Mound Group in Iowa. So this is just an example of a view of some of our sacred sites. This is obviously Ho-Chunk, and other tribes have origins and ties to a lot of the effigy mounds. And I've been out there myself several times. But how do you preserve that environment? And in this case, the preservation happens with this particular group of mounds because it's in National Park Service protections. What if it wasn't? And that is the biggest #1 problem tribes have, is they have so much to protect, but they don't own or control those lands. And so, we have to look at things like, how do we utilize the National Park Service? How do we utilize those processes to have environmental justice in our world? And I'm not going to spend a lot of time on this, but folks that are new to working with tribes are just knowing even a background. I think we did a whole 1 or 2 day session just on federal Indian law alone. And this takes up an entire semester or two in law school. But in 5 minutes, I'm going to go over it right now. There's a federal tribal relationship, and I alluded to this earlier with the Bureau of Indian Affairs. And the federal tribal relationship is the primary relationship that is key to environmental justice. It is the beginning and end to environmental justice for tribes. Generally, for sovereignty, a lot of tribes and people that are not familiar with tribes and tribal law believe that sovereignty is all-inclusive and it's absolute. And we ourselves, as part of our culture, we know theoretically that's what it is and that's why we're here. But in the books, it's actually something very different from that. And because it's different than that, means we have all these problems with environmental justice. What's left for tribes? After the treaty era, after the major acts were passed, what was left that tribes have power over? And we always like to say we're the sovereign tribe of so-and-so, the sovereign nation of so-and-so. But when it comes down to it and litigation happens, this is really all that you have left. Tribes have the ability to govern their membership. They have the ability to form their own tribal government. They have their ability to govern their own members and the territories for which they have jurisdiction, and that's almost always found in their constitution. They have the ability to administer justice. That's not absolute. It's very limited, as we're going to talk about in a second. And they also have the power to exclude, and that's becoming a new popular trend in Indian country, where tribes are passing banishment ordinances and getting rid of, problem families that don't have the blood quantum. It's a political membership. It's not necessarily a racial right to be, included. So tribes are now starting to exclude members for a variety of reasons. The important thing is the Wheeler case, and this is pretty much nails it. Indian tribes still possess those aspects of, no, you can say all sovereignty, aspects of sovereignty not taken away by treaty or statute or by implication as a necessary result of their dependent status. So what are tribes? Tribes are domestic dependent nations in the law. They are domestic dependent nations. We are not independent under the law, under the Supreme Court cases that are still good law from the 1830s. We are not. When it comes down to the black and white, we are not independent. We are very dependent. Some examples where they've also cut into sovereignty beyond those general rules is these acts right here. Limitations on conveyances of tribal property. The 1940 act that says tribes cannot even sell their own property. You have to go get a congressional act passed for you to sell your own fee property. It's old. I don't know. It's there thinking that tribes they don't have the competency to deal with their own land titles. So they have these laws and that Congress is supposed to protect them. You can't do things unless we do it for you or we approve of it. The General Allotment Act, where they took all the tribal reservation lands and they allotted them to individual tribal members. They're trying to show and demonstrate and force tribal folks to become individual property owners and assimilate into society. So they cut up all the properties and they divvied them out, and obviously, like today here in Oneida, we have checkerboard jurisdictions as a result of this General Allotment Act. The tribe, in this case, obviously, did not have control over its territory. The government took it back by passing this act. And of course, we know we're like Oneida, they have to buy it back just like anybody else. On the Major Crimes Act, one of the original things we have the ability to, I said earlier, administer justice. Well, we do and we don't. The Major Crimes Act is a very good example where they take 7 major crimes and they pull that jurisdiction away from tribes. Anything, manslaughter, arson, kidnapping, all those major crimes, the FBI comes in. Tribes do not have that jurisdiction over the major crimes. We are allegedly not competent to administer justice over major crimes. Only the feds can do that for us. Indian Civil Rights Act, they want to make sure that we're afforded civil rights to our membership just as America does. That's a big implication on sovereignty. And then, of course, one of the biggest issues, and a lot of states are not familiar because they don't have to deal with Public Law 280, but we have that here in Wisconsin. In 5 states, we're mandatory states. Public Law 280 was passed, I want to say, began in the 1940s, where a lot of states were very upset with tribal communities and said, okay, states, we do not like having to pay for a fund and deal with justice issues for these tribes. We can't afford to do it. The tribes can't do it. We want jurisdiction taken away from the tribes and given to the state so that we're able to help all this lawlessness and help these poor tribes out. Most states actually didn't opt into that. The 5 states that were mandatory included Wisconsin, California, Washington, gosh, I can't remember all of them. They're now required there's more state jurisdiction within tribal communities that isn't typically there. So for instance, I was jokingly saying I'm actually a contracted prosecutor for the Fort McDowell Yavapai Nation down in Arizona. So I prosecute anywhere between 30 and 50 criminals a week, and I'm usually in court 2 to 3 days a week. And why am I doing criminal law? Is that, usually not a criminal lawyer, but would I be able to do criminal law in Wisconsin? No, there are no Indian criminal lawyers unless you're up at Menominee, which has their criminal jurisdiction. You really don't get much of a chance to practice and do criminal law practice unless you're in a jurisdiction where they have that authority. And in Wisconsin, quite frankly, we don't quite have it yet. So those areas are developed. Law enforcement, criminal jurisdiction, they're all under major developments. They're major agenda items for the tribal councils here in Wisconsin. And that'll probably change in 5 to 20 years. So we'll be watching that happen. So in the end, tribes are neither states, and they're also not part of the federal government, and they're not even subdivisions of either one of those. They are sovereign political entities possessed of sovereign authority not derived from the United States, which they predate. So this is the strongest case that says, where does your sovereignty come from? It predates our Constitution. That's the sovereignty that you have, but for when Congress, who has what they call plenary power, absolute power over tribes, they can take that away. So generally, what does that mean for our relationship? Well, how does that translate today? Well, again, back to this is where it begins and ends for tribes. Tribal sovereignty has never been extinguished. The federal government's unique relationship with Indian tribes has evolved from treaties, statutes, and courts. It's been reaffirmed year after year, legislation after legislation. Every agenda will reaffirm that the federal government is big brother to us. We have a trust responsibility. They take care of us. We have a lot of incompetencies under this relationship status. It's very similar to how a guardian is to his ward. Same analogy, always discussed in courts, argued in courts, day in and day out, still to this day. And the scope of that is, well, if we're supposed to be so taken care of by the federal government, how much does that mean? How much taken care of does that mean? And the scope is supposed to be absolute. They're supposed to provide education, health, welfare, all these things for tribes. And of course, do they do that? Well, they've continuously failed decade after decade. Tribes actually stood up and started saying, okay, federal government, we can't do all these things. We have to live under this rubric of sovereignty that's left, whatever, just this little bit that's left to us. And we can't govern our people effectively because of your restrictions. And now you're supposed to take care of us. How much are you going to do that? Are you doing it? So the question is the enforcement. So tribes have been stepping up since day one saying, well, where is our 40 pounds of flour? Where is our barrel of salt? Where is our ponies at? Why is this stuff really, we make these elaborate treaties and you don't deliver? Again, enforcement examples, back in the 70s, the tribes had so many breach treaty cases. They were just coming out of everywhere. You had attorneys that were looking at Indian law that hadn't developed yet. These are all new case laws, and the Bureau and the federal government said, gosh, we don't even know how to adjudicate all of our broken treaties that we have. So they opened up a small window in this Indian Court of Claims, and it's really interesting if you ever Google this and you take a look at some of the cases and the treaties that were disputed. They finally just allowed all of them to come in through this window. They settled the broken treaties during this window, and there's a lot of case law. And why Indian Court of Claims cases is important, because that's where tribes ultimately had a dispute. Let's say Ho-Chunks gave up 10.5 million acres, and there was a Menominee settlement right in the middle of that acreage. And Indian Court of Claims said, well, how are we going to settle this? Well, now they have to dissect all of the history and decide where exactly does Menominee have land within that land cession. And so they're all written in case law. So you learn a lot more. There's a lot more background to tribal sovereignty and also redress under their treaty provisions. And also, as you know, like the Cobell lawsuit, everybody's currently looking for their next Cobell check in December. Breach of trust claims, they're supposed to be handling our Indian money accounts. And they're found in contempt of court. The Bureau of Indian Affairs destroyed a lot of its records to account for millions of dollars of Indian trust monies. And there's big law firms sued them. They engaged in a settlement. They're doing payouts currently. And so the tribes have fought back and said, okay, where's your trust? Where's your trust? Where's the trust in this relationship? And where's the justice? So these are examples, and you can also dispute a lot of agency issues through the Administrative Procedures Act, which is also a very common method of resolve. So these are ways that tribes are looking back to the government and looking for relief in this plenary power that Congress has and this guardian-ward relationship that we have to live with. Okay, so that's the background in Indian law. That's supposed to set your framework up to understand how we're going to approach environmental justice in Indian country. And it's very important to know that environmental justice, environmental laws were actually pretty silent and actually not there for many decades in the United States. Development happened. What's most important and pinnacle was in the 1960s with the civil rights movement. And as you know, in the civil rights, it wasn't just civil rights, it was a number of other things, since folks that were pioneering and very active in the civil rights movement, they got the stage, and one of the things, hot topics, was environmental laws and justice. So that caught Congress's attention, and it got put on the agenda. And in terms of environmental justice in Indian country, the EPA had to take a quick look because of their guardian-ward relationship with tribes and said, well, what policies do we need to do to live up to our responsibility to tribes? So in 1984, they passed a policy. It's called the EPA's Policy for the Administration of Environmental Programs on Indian Reservations. And it's dubbed, and forever will be dubbed, the Indian Policy. So it's really the foundational policy of the federal government, how it's going to work with tribes and support environmentalism on reservation lands and for tribal communities. And this, of course, came from President Reagan, who was a big environmentalist advocate in his administration. And you'll see it's very political. Environmental law, and like any other body, becomes very political. Is it in the agenda of that administration or not? And that's really what happens. So in the 80s, there was just a ton of environmental policies. The EPA, grew very, very big. Policies happened. Outreach to state offices really happened. Funding was there. In 1994, we fast forward to President Bill Clinton. Executive Order 12898, and that is the order that frames the federal government's position on environmental laws for Indian country. And we're going to talk about that in a minute. Later on, the administration, the baton got passed to President Obama. And Obama, again, the question was, well, now that President Obama's in, all the tribes said, as part of environmental justice, hey, President Obama, we want you to support the UNDRIP, the United Declaration on Rights of Indigenous Peoples, which is a very general, broad statement of environmental justice, and says we need to stand up for our environment. We need people to listen to our very valid positions on our environment. And President Obama announced that he actually supported that, which was a big shift and a very difficult thing. And while UNDRIP was written, again, like I mentioned earlier, I was studying in Switzerland for the summer and working at the Indigenous Peoples Program, where we were actually advocating and lobbying the Working Group on Indigenous Peoples to politicize and try to gain the votes needed to pass the UNDRIP, which happened way later, of course. So I got to see and actually sit in the UN meetings and go to hearings day in and day out in 7 different languages and hear internationally what people thought of the UNDRIP. All these different tribes, very, they literally spend their entire budget just to get to the UN to weigh in on something like the UNDRIP. So it's so important for the United States to actually take that position and support it. And tribes lobbied President Obama in the White House pretty heavily, and he turned around and said, I support this. So tribal leaders were just amazed that, that quick in his administration, he was going to step up to this declaration. And that led to this era now, which is extremely active in environmental law. And so we're in 2011, he had passed the EPA's, and it's kind of a revised version of the old Indian policy. It's called the EPA's Policy on Consultation and Coordination with Indian Tribes. And what Obama did is he went back to his cabinet and said, everybody has to come up with new consultation policies, and they are going to be enforced. And so the EPA stepped up, and they kind of had some things in the works anyway. There are some working groups out there. And they passed this new consultation, and it's a very diplomatic way of working with tribes on environmental issues. Now, what is the pinnacle next dealing with, and I'm just going to point this last guy out here, is there's a draft of that's out there now. It's called the EPA's Policy on Environmental Justice for Tribes and Indigenous Peoples. Are you seeing the Indigenous Peoples theme getting incorporated from UNDRIP into this new draft? And the draft went out to tribes, I believe, in 2012. I think their comment period ended sometime in June this year. And right now they're compiling all of that input and comments to that policy. And policy is huge, and you're going to see why it's so huge. So we're going to be looking forward to this new policy. We're going to be looking forward to the criticisms. It's going to be a new policy that's obviously going to be exercised, challenged, and vetted for many years to come. But this is a huge change in environmentalism, environmental law for Indian country. And here's a little bit, I've just pulled some language from 12/8/98, the executive order from Bill Clinton. It says, to the greatest extent practical and permitted by law, each federal agency shall make achieving environmental justice part of its mission by identifying and addressing, as appropriate, disproportionately high and adverse human health or environmental effects of its programs, policies, and activities on minority populations and low-income populations. That's huge. That's a huge move from President Clinton. And generally, what is environmental justice? What is the real meaning? And it is fair treatment. It means that no group of people should bear a disproportionate share of the negative environmental harms resulting from industrial, governmental, and commercial operations or policies. So fair treatment. And the other half of the deal is meaningful involvement. And I'm sure everybody in this room at some phase has been part of some sort of consultation. And it's in your own eyes subjectively. Was it meaningful? How meaningful was it? At one point did it become meaningful? So meaningful involvement means that people have an opportunity to participate in decisions about activities that may affect their environment. Now this is very different. You think about, we'll consult you, so you tell us something, and you weigh in what you think you want to do, but you don't actually really participate in the actual decision making. And I think that's where people get a little upset in the consultation process. They think they're weighing in and they're helping form a decision, but they're really not. They're weighing in on a decision, but they're not actually making the decision. They're not decision makers in the process. So that's the important aspect and key part that tribes are really looking for here. Public contribution. Concerns will be considered in a decision-making process, and that's the big part there that I was just mentioning. The decision makers seek out and facilitate the involvement of those potentially affected. So it can't be in the here and now too. We really have to have more of like a 7th generation vision with this decision making. And again, back to the granddaddy, we call it the grandpappy of environmental law, the Environmental Protection Agency. Now this is generally a nice little simplistic bubble diagram, flow chart of how things happen in their world. And it really comes down to yes or no, yes or no. So you have a project, you have this project, I'm just gonna walk you down it. You have a proposed action, so it's an action. What are they gonna do? Are they going to dig for clay here? Are they gonna put a frac mining site here? Are they going to reroute waters? What are they going to do? What is the action? And so they have this action, and the first thing they vet out, well, is it a KTEX, a categorical exclusion? And this means it doesn't need to go through all this intense public hearing, policy, drafting portions. all it needs to do is go down and get done. It needs to go right down to this bottom bubble here that says take action. And if it's a K-text, it fits neatly within one of these categories, which essentially means that there's no significant impact. So if you're already doing something, if they're already routing water a certain way and they're going to do it some more with a certain type of nuance that really doesn't change or have any significant effect that's already going on, then you're usually categorically excluded. You don't need to review any new thing because nothing new is coming your way with this project. So you can go through a K-text process which circumvents the entire process. People argue for this all the time. A lot of people try to get a K-text determination from the EPA as soon as possible so they don't have to deal with the public and this very expensive other part we're about to talk about. If they don't get their K-text, then the first question is there potential for significant effects? What does that mean? You know, what is the potential for effects? And are they significant? If they're not that significant, and there's legal details on what is significant, what's not significant, if there's no potential for significant effects, you would go down and you would just do this review process called the EA process, the environmental assessment. And these aren't very expensive to do. They're not very in-depth. They're not required to be. And most companies obviously do the minimal, whatever the law requires, and that's pretty much it. So there's an environmental assessment on the project and the scope. You also, in the process, you're going to determine how much public involvement is necessary. If any is necessary at all, they'll make that determination and they'll qualify that with reasons. And once they do that, they can go ahead and they can find that once they go through that process, they can then discover at that point whether there are significant effects. And at this point, they can realize when they dig a little deeper on a very superficial level, oh wow, there really are a lot more effects in here that we didn't consider when we were up at the top of this chart here. So if they do discover in that preliminary EA that there are a lot of negative and adverse effects, then they need to go back to this more difficult process right here, which is the environmental impact statement process of this review. So if that happens, they're back up here. If not, then they're going to do it's called a FONSI, F-O-N-S-I, a finding of no significant impact, and then they can take action. So that's kind of the pretty fast way of doing it, the cheaper, easier way. But again, if you have problems, you got to go through what's considered the hardest way. Now, typically, the developers that I've run into, the litigation, whether it's on the administrative level or it's actually in state, federal court, we're usually in this third line here, which is the more critical and in-depth analysis of any project. You begin the environmental impact statement, so you have to scope. And scoping is so important, and that's why they say we got to talk to these tribes early on. And tribes need to be part of who they're hiring for contractors and make sure they're qualified. I mean, why would you want an archaeologist from Atlanta up here doing work in Wisconsin? What do they know about this regional archaeology? These are questions, and valid questions that have popped up in projects. Who are they going to hire? Can you be part of the hiring committee to find out which contractor, the RFP, review RFPs and look at their qualifications? Who do you want working on or near your tribal communities? Are they qualified? Do they have a good rapport? Are they just the cheapest person who will do it? Tribes got to weigh in on that scoping part. How in depth are we going to look at things? And here's where it matters. Like if it matters to you about medicinal plants or things that are in that area, is the scope of that environmental assessment going to cover that medicinal plant enough? So tribes have to get involved very early and be very specific and technical and throw everything they can out there in terms of scoping. So once the scoping's done, they put the scoping out for public comment. That's a required public participation process that has to happen. So they say, okay, everybody, we're going to do X project. And here's the depth of the project. What do you think? Is it in depth enough or is it okay? And so they take all those comments, they take them into consideration, and they might modify their scope. They may not modify their scope, and then they start hiring and putting off these contracts and consultants and bringing in all of this data to say what is the adverse effect, how significant is the impact? That's the question of the day. How significant is the impact of this project? And once in that process, they'll draft an environmental impact statement. So it's only the draft, so it's called the DEIS. The DEIS will come out, it's out for public comment. It's usually on agency websites, and they're voluminous. I mean, I literally have files and files and files of the projects I've worked on. These EISs are huge, and you have their consultant reports. And typically this is when, if I'm working for a tribe, they'll say, okay, wow, they put out a draft environmental impact statement, Samantha, and we don't like this, or this. So I'll have to go back and do records requests from the agency and really get down and dirty so that we make the timeline to put in comments that are tangible and technical and that will hold up in court down the road. So that's what happens with the DEIS. Once that 45-day comment period is over, it's over, and they typically don't extend them. Tribes have been successful in asking for extensions of public comment periods for various reasons, and most of which are they haven't been consulted, they didn't receive technical reports on time, all those sorts of things. Whatever the reality of the situation is, sometimes they will extend the public comment period, but it's usually only for extenuating circumstances. Then when all of the comments are in, the agency will compile all the data, and they'll briefly answer, summarize them, and they'll briefly answer all of those issues that have been received, and they'll put out a final EIS. So the final EIS will have a back section, or appendices of public comments and how they've addressed them. And so that's considered the final environmental impact statement. And this is the end-all, be-all of the project. It says how much impact is there. This is where your environmental justice issue is probably going to be planted in the words in that final environmental impact statement. And that's what your attorneys and that's what your staff have to live with, unfortunately. Then they issue a record of decision. So they usually typically try to come up with a FONSI. They'll try to mitigate all of the impact issues before they get to the ROD, the record of decision. So that's the review process in environmental justice over the majority of the projects that affect Indian country. That's really how it happens. And I wanted to show you, well, how does it also really happen?